Law and economics, to me, a very challenging but yet hopefully extremely helpful class for you. My background is as an attorney with 3 law degrees, MBA, all of that stuff, actual practice of law. Now, what I want to deal with is how law works and the overlapping of the legal process with economics. The behavioral aspect of economics, law is what significantly influences that. So when we think about violence, some of the kind of topics that you've heard already and read about, we need to look at this historical perspective. I have in your materials today the Magna Carta that deals with just that. How did a king become a king originally? Through violence. The stronger party with those individuals willing to assist them would then rule the country through force, violence. The idea of might makes right is the kind of traditional term. Or even if we think of Alexander the Great or Roman emperors, in many societies today that has changed. Why? Because of legal aspects. The idea, though, with violence is violence doesn't require an agreement. We're going to be talking about contract law, which deals with the idea of agreement, okay? But violence can involve tort law and or criminal issues, and we'll talk about tort law and criminal issues throughout this course. So what I want to have available for you is information about the Magna Carta. King John in 1215, under threat of a civil war, the idea of violence, agrees to 63 things. Many of those are very specific rather than general principles. A few of them are general principles, but mainly specific items that dealt with grievances. Now, I also have in this material online information about the Mayflower Compact. Okay. Mayflower Compact, developed in 1620 with 45 male members of the Mayflower. Today we call them the Pilgrims. Compact just means agreement, covenant, or contract. For our perspective, all of those terms will mean the same thing. Now, if we're talking about the Mayflower Compact, which was the Pilgrims coming to America, John Adams and many historians refer to that particular compact, that contract, as being a foundation of which the United States Constitution was built on 150 years later. Now, this chapter 1 that we're going to start covering deals with general rules. Okay? So the idea of general rules, some rules are just, some are unjust. When we talk about rules that are just, we mean fair. Quite often we'll hear someone say, that isn't fair. In legal terms, we say it's not equitable. Equity is the term we use when we're dealing with something that isn't just fair or right. Okay? So under our legal aspects, we do set up particular things that basically are outlined or are bureaucratically set up in regard to what we would call laws or rules. With that in mind, we call those particular things positive law, which normally you'll read and they'll say the law. Now, if there's an exception, because it isn't just fair or right, how that law is applied to certain circumstances, we call that equity. So let's try an example. Let's imagine I'm driving down the street and I'm going through an area that's in front of a school. So I'm driving in front of a school, and the speed limit here in Indiana during certain parts of the day in which students might be out, like lunch hours, when they are walking to school, or maybe when they're leaving school, the speed limit is 20 miles an hour. Quite often, in many locations, it's 30 miles an hour at other times. So I'm used to driving 30 miles an hour in this particular zone, unless it's one of those 3 times. So if It's one of those 3 times. The area I drive through has a flashing light, and it says the speed limit is 20 when the light is flashing. Okay, the reason for the flashing light could be just a sign, but in this instance, it's very easy to see. It lets us know that there's a safety issue. We need to slow down, so in case a child walks out or runs out in front of us, we'll have a chance to stop for them if we're going slower. So with that in mind, we have laws under positive law that says you have to slow to 20 miles an hour. Okay? Now, let's imagine it's a break. It's Thanksgiving, Christmas, some particular spring break for the school, fall break, and let's imagine it's a high school or junior high. So if we think of that, I have a son that's in high school, and I know when the breaks are. So let's imagine it's spring or fall break, and I know there's a break, and the lights are still flashing. Why? Because they don't have an automated system that they set up to take into account all of these breaks, and maybe the break's only 1 or 2 days. With that in mind, I know there aren't going to be any children out in the road. Why? Because school isn't on, but the light's still flashing, telling me to go 20 miles an hour. But I'm aware that no one's there, none of the children, so I'm going 30 miles an hour. Police officer, in my hypothetical, radars me, stops me. Now, have I violated the law? Yes, I wasn't going 20 miles an hour when the light on the sign was flashing. Okay, that's positive law. Now my argument falls under equity. It isn't just fair or right to require me to go 20 miles an hour when there isn't a safety issue. No reason for this particular slower speed. So that's the argument. Now, I still get the ticket. I have to go to court. If I can get the judge to use equity, I wouldn't have to pay the fine. Change that a little bit. Let's imagine it's a grade. So I'll use my wife as an example. She went to a school that only gave A, B, C's, D's, and F's. They didn't give minuses or pluses. So she had an anatomy class where at the end of the term, she was sure she had an A. So she goes back and checks her exams, her projects, her quizzes. Yes, she has an A. A 90% was an A. Any lower, like a 89, is a B. 80 is still a B. 79 is a C. All that particular way. So, end of the term, she gets her grade. She finds out she gets a B, not an A. Again, she checks everything. She has exactly a 90%. So she's really upset. With that in mind, talks with me, and my response was, well, the requirement through the rules, the policy for your school, is that you talk with the instructor first. If you don't like what the instructor says, then you have the right to appeal that, and that's to a committee made up of students, faculty, and an administrator, and then they will decide. If you don't like their decision, you can appeal it to a higher level within the school, usually the president or provost. Okay. So she talks with the instructor, and the instructor looks at her grades and says, oh no, you didn't have an A, you had a B, just what I gave you. You had an 89.99999. Well, my wife had set her scientific calculator, to truncate at the 4th decimal place. So it rounded that last 9 up, which made it a 90%. That's what we do in math, that's what we do in science. But in this situation, the instructor didn't round up. She had an 89.9999, which was a B. Now, under positive law, that's correct. Her argument could have been, she didn't appeal it, I tried to encourage that, but an appeal. Now think of it yourself. If you got an 89.9999 in a class that only gave the straight grades rather than pluses or minuses, and 90%'s an A, 89%'s a B, what grade should you get? Well, under equity, I would think you're entitled to an A, not a B. Now, the idea of equity again. Think of things beyond just the laws. Let's imagine that my 16-year-old son wants to go out on school nights. So I tell him that he has to be home by 10 o'clock. It's a school night, you have to be home by 10. With that in mind, that's a rule. right? Could think of it as a law, same idea. So, if he isn't home by 10 o'clock on a school night, no TV, no video games for a whole year. Let's use an extreme example. So, he's definitely wanting to be home by 10 o'clock. Well, here's a particular evening. It is 5 minutes to 10, and he's coming home, but our home is on fire. The police already have the yellow tape out all around the area, and they're not letting people get close to the home, yet he wants to go under the tape to go into the home. Why? Because under the rule, the idea of positive law, if he doesn't go into the home, he'll lose all of these things. Should he have to go into the home when it's on fire? No. This is an exception under equity. Okay. Positive law, the rules, I didn't think of making that as an exception. I could have said an exception is if you're out on a weeknight with me and I'm driving and we don't get home before 10. If there's a burglar in the house, you can leave the house. You don't have to be in it at 10. All kinds of different exceptions. A lot of times our laws, or even our rules that we have, like company policies, don't include all of the exceptions. It's a straight rule, and then if it isn't just fair or right, the idea is that we use equity. Okay? That's what we look at. Now, let's look at this outline I have before you, showing the chapter, as I mentioned, the Magna Carta, Mayflower Compact. That is just included in this material just to have you kind of skim over to see how some of the ideas between restrictions on government, meaning the king, came about, and then just agreements by the parties, that's the compact, the contract, deal with particular aspects of how our laws were created. And then the idea of positive law and equity and how equity works. And then what I want us to look to is this idea of what is involved with the laws. Well, positive law was the king's law. So let's go back to times before Henry VIII, because we had a separation of church and state in England, and United States laws, we contend, are built on English laws. Well, yes, they are, but they're also built on laws from Roman law, from Egyptian law, Babylonian law, but in real life, what attorneys are always taught are that our basis of our laws are built on English laws. So that's what we deal with. So the king's laws we call positive law. Now, we also had the church's laws. Those were considered equity, a person in regard to a civil matter. We'll talk in a few minutes about the difference between civil and criminal matters. In a civil matter, the person could choose, did they want to sue under the king's laws or under the church's laws? The idea of the king, all of these rules that are set out, that's positive law. Under the church, we have rules, but it deals with equity, what's just, fair, or right. The idea of how the laws are set up. So two distinctive aspects of the law. Then constitutional law just deals with a foundation, right? Normally people will think of the Constitution as rights. Well, when we think of our first 10 amendments, the Bill of Rights, those were amendments to the Constitution. The primary function of the Constitution was this idea of a foundation of how the government should work. So we have the legislative group, the Congress, Senate and House of Representatives. We have the executive branch, the presidency, or in a state, we'd call that the governor. And then we have the judicial branch, which is just the court system, and set up how those particular systems are supposed to function. Primary purpose of the laws. Then we have things like, we could say, treaties, congressional laws put together in either trade or things that we will or will not do. Okay? So Constitution, the highest level. Then we have treaties, the next level, and then we fall below that with things like statutes. Okay? As you read things, statutes mean the same as codes or mean the same as acts. So if I say codes, that's a statute. If I say acts, that's a statute. If I say acts, that's a code or a statute. They all mean the same thing. It's kind of like saying, what is the difference between an attorney and a lawyer? There isn't. They mean the same thing. Under the English system, though, we have solicitors and barristers. Solicitors can't go before the court. They simply are counselors working with the particular individuals. The barristers are the particular individuals that go before the court and argue cases. So English law, a little bit of a difference in that regard from American law. Okay. Then we have things like ordinances. Now these aren't things that blow up, right? They're not the small bombs that are used in war. Ordinances in this instance are what we call city or county laws, or small governmental organizations. So ordinances like a city ordinance in regards to a speed limit, building codes, even times that you can use a park, let's say. Then we have administrative regulations, which are called rules and regulations, and that's from an administrative agency like Occupational Health and Safety, Environmental Protection Agency. We have all of these different agencies, federal and state agencies, that also create laws. Okay. Now they have to be in compliance with what? The idea of statutes and the Constitution. And then we have what we call common laws, or common law, case-based law, judge-made law. All three of those mean the same thing. It just means that the courts have either created a law or interpreted something like the Constitution, a statute, a regulation, an ordinance, a treaty, and that interpretation now is a law. We call those common laws. Judge-made laws, case law, all meaning the same thing. Now, what I'd like to talk a little bit about are the two systems of law. We have criminal and civil law. Okay, what's the difference? Well, criminal law is injury to the public. Okay, so if by chance I hit you, that's a battery under both criminal and civil law, but the government, the prosecutor's office, decides whether they want to prosecute me, hold me responsible for your injury. Most sovereigns, they don't care whether you want me to be prosecuted or not. Some sovereigns will, and they will because if you don't want me to be prosecuted, you might not be a very good witness is all. But the government still has the right to bring the action to protect society from me, from these particular actions. Now, civil law is I've hit you, the same term battery, but now if I knock out a tooth, if I split your lip and you have to have surgery, you're entitled to your damages. Medical, wage loss, pain and suffering, all of those things. Now, when we talk about these two systems of law, someone might prevail in criminal law and lose in civil law. Someone might lose in civil law or prevail in criminal law. Now, in civil law, the example I used is you as the individual now bring the action. You're the plaintiff. You're complaining. Then you have the person that's defending themselves. That's the defendant. When it's dealing with criminal law, it's always the government doing the prosecution. They're the plaintiff. We, or me in the situation if I hit you, I'm the defendant. I'm trying to defend myself. Now there's a different burden of proof depending on whether it's criminal or civil law. Under criminal law, if I hit you, the government has to prove beyond a reasonable doubt, okay, beyond a reasonable doubt that I've actually hit you. So if you and I are the only ones in the room and I deny it, it might be hard for the government to prove beyond a reasonable doubt, meaning a very, very high percentage, 100%, 99%, something like that, that I actually caused this particular injury, because it's your word against my word. But in a civil action, meaning for that broken tooth, that split lip, the stitches, the medical, the plastic surgery, the wage loss, under a civil action, all you have to prove is what we call a preponderance of the evidence. Just that it's what? More than 50% likely that I did this to you. So a civil action is easier to prevail under than a criminal action. The criminal action, beyond a reasonable doubt, Civil action, just a preponderance, more than 50%. Okay. Now keep in mind, as I have listed right here, the idea of criminal law is to punish individuals, it's to deter, alter behavior. The idea that economics looks at is behavior of individuals. Now, I've gone through the aspect of civil law on this particular piece of material. You know who the plaintiff is, the party wanting their damages. Under positive law, very easy to determine. Now under equity, that means these exceptional circumstances, whether it's criminal law or civil law, the party, meaning government or the individual, can ask for injunctions. Normally injunctions say stop doing that. Stop making that particular product because it's harmful to society. Stop coming to my home and bothering me. Or we could deal with the idea of equity as specific performance. What specific performance? I want that thing. I don't want something else. So if I want that thing, meaning it could be land, a house, or some unique piece of property, the idea is it can't be mass manufactured. It has to be unique. And if money damages aren't adequate, then we argue under equity that we should get that particular thing. Traditionally, that deals with contract law that we'll be talking about later. Under equity, there can also be contempt of court. If you've ever seen the movie My Cousin Vinny, very good with showing contempt of court. The court is simply telling someone or some company that they want them to stop doing something or they want them to do something. And if they violate what the court has said, then they're in contempt of court, and now they can be put in jail for that. For how long? It depends. There can be a specific time period that the court decides, meaning the judge decides, or it can be a time period until they modify their behavior. Those things are what we deal with. Now, civil law. I give you all of these pieces of information: contracts, torts, property law. There's real and personal property. Real property is land and anything attached to it for its reasonable life. Personal property are those things that are movable, right? Not dealing with land or something attached to it for its reasonable life. So personal property is a chair that's movable, a camera that you can move around, your clothing, jewelry, watches, those type of things. That's personal property. Civil law also deals with things like insurance or agency law. We'll deal with that in the idea of you asking someone else to do something on your behalf. You've requested them to do it, and now you control what they do. So like an insurance agent, real estate agent. And we have employment law issues that deal with what? Civil law, built on contracts. Now, some employment issues could involve criminal activities. We have warranties in regards to goods or services that you buy. Civil law, bankruptcy, also civil law, malpractice, consumer protection, negotiable instruments, wills and trusts, all of those types of things deal with civil law. Okay. Your author, as I'm showing, deals with 3 areas of civil law, and those your author talks about are property law, torts, and contracts. And we're going to go into detail in future sessions with those individual areas of law. Each of them have their own set of legal rules. So as you can see here, property law, as I've mentioned, is only a bundling of rights defined by what? Those particular statutes, ordinance, codes, regulations. Okay. Now, in your text on page 103, it says, where does law come from? Okay. Well, this is in regard to tort law that the textbook is dealing with. A tort is a civil wrong, okay, a civil issue. It's a wrongful act or omission. So if we say wrongful act or omission, what are we meaning by that? Well, an act can be something you do. An omission is just something that you're supposed to do. So The idea of civil law is a private wrong. Remember, criminal law is a public wrong where society wants to enforce particular standards. So, with this idea of civil law in regards to tort law, let's use a simple example. Let's imagine it snows. Snow. Well, a person that either owns or leases particular property is supposed to clean their sidewalk within a reasonable time. If they don't clean it within a reasonable time, they have committed an omission. They should have done particular activity and they didn't. They omitted from doing it. And if someone's injured because of this omission, they can be liable. Now, let's imagine that they cleaned their sidewalk, but they did it in a hurried fashion and they left lots of ice on it, and a reasonable person wouldn't have done that. Well, in that instance, they also can be liable for negligently cleaning their sidewalk. That's the idea under tort law. We have things like negligence and strict liability. So in your materials, I give an example. Well, let's say I don't give an example in these particular materials. I was thinking when we deal with tort law, and I do. I give an example of a situation in which an individual doesn't clean their sidewalk. Very simple. Or we could have a situation in which you're following a big dump truck, and now a rock comes up from the ground as you're following a dump truck and breaks your window. Is the dump truck driver responsible? Well, it depends. Under tort law, we have to determine was the driver negligent. Okay? So if you look down, you'll see the definition of negligence. There's a duty, breach of duty, proximate cause, and damages. Proximate cause just means a causal connection. Okay? So in this instance, you're driving along. If they've overloaded the truck, and rocks fall or sand or dirt falls off from the top of the truck, then they were negligent in how they loaded the truck. They shouldn't have loaded it so full, or they should have had a cover over it, so there's a breach of duty. They have a duty to keep the material from coming off the truck and injuring someone. Proximate cause, was the broken window from the rock off the truck, or did you have the broken window before the rock hit it? Well, we'll say that it came off the truck. That's a causal connection. We call that a proximate cause. And now you have damages. Well, if we change that a little bit, let's imagine that they didn't overfill the truck, but there were rocks that were on the bumper of the truck from when they filled it. Should have the driver cleaned those rocks off? Yes. If they didn't, they breached their duty. Now, one of those rocks falls off, hits the ground, and because of the speed of the truck, breaks your window. That's the proximate cause. Now, again, if your window wasn't already broken, damages. We change that a little bit and we say the truck is driving down the road and a rock flies up from the tire of the truck. And let's imagine that they have mud flaps that fit what's required by that sovereign. So that state or the federal government requires on this size of truck, our example, a dump truck, a certain size of mud flaps. They had that size of mud flap. So they didn't do anything negligent. So even though your windshield broke, if it was a rock coming up from the ground where the tire throws it up and they had the right size mud flaps, you suffered a loss, yes. But there was no breach of duty by the particular driver of the truck. So the idea of tort law, in this instance, negligence, it's a private wrong, it's a civil wrong, or it isn't. There's no right for recovery. Now, within tort law, we also have this aspect of strict liability. What does strict liability deal with? Well, it deals with the aspect of absolute liability or product liability. So the overarching area is strict liability, and we have two things that fall under that. This idea of absolute liability or an inherently dangerous aspect like a product liability issue. So with that in mind, let's use an example of strict liability where there's absolute liability, meaning absolutely dangerous types of activity. So with that in mind, we say, what fits in that category? Well, remember with tort law, under a civil aspect, the plaintiff has the burden of proof and they have to show that there's a duty and that the duty's been breached. The idea with strict liability is we don't have to deal with this breach of duty. If someone is injured, we just say they're responsible. So if it's absolute liability, meaning absolutely dangerous activity, we have things like explosives, dynamite. Let's imagine you have a particular party that's blowing up a building. So they're going to implode the building and have it fall on itself. And let's imagine a piece of concrete from the building flies off and hits you or your car, and you're blocks away, meaning the area they have quarantined off, fenced off, you're beyond that. So you weren't within the danger area, but it still injured you or damaged your property. They're just liable. That's all it is. Why? Because it's an ultra-hazardous type of activity. So if it's ultra-hazardous, this absolute liability comes into play, and the particular party that's doing the activity is responsible. Same thing with storage of flammable materials, crop dusting, but we also have wild animals. Wild animals. Well, we have wild animals and we have domesticated animals. So what's the difference? Well, domesticated animals are things like cats, dogs, horses, cattle, sheep, pigs, chickens. Those are domesticated animals. If one of those animals injures you, we have to show that there's a duty, meaning for the person owning them, to not let them injure you, and that they breached the duty, and that it was actually one of those animals that injured you, one of the domesticated animals, traditionally a dog. A third of all insurance claims relate to dog bites, and that you suffer damages. Now we change that a little bit and we say, let's imagine it's a wild animal. What's a wild animal? Well, we see insurance advertisements. A gecko is a wild animal. A tiger, a lion, a bear, wild animals. A hippopotamus, a wild animal. Around here we have deer. We could also say, not here, but in other areas, moose, elk, all wild animals. So, if by chance an individual takes possession of one of those wild animals and it injures someone, so let's imagine it's a cougar and you've raised it from a cub, and now when you're out walking it, I can't imagine walking a domesticated animal on walking them if you have one of the leashes. Tried that with a cat, not very successful with it. But this larger cougar, let's imagine you've trained it so you can walk it down the sidewalk, and now it injures someone. It bites them, it scratches them. With that in mind, we say you're just liable. This idea of an ultra-hazardous type of condition, absolutely dangerous, it's a strict liability aspect, responsible. Now, if we deal with the other area of strict liability, this idea of product liability, doesn't have to be quite as dangerous. We say it's inherently dangerous, and the courts, the judge, decides what is inherently dangerous. With that in mind, let's imagine that we have a trampoline. Is a trampoline inherently dangerous? Well, the courts have said yes, they are. How about a rotary lawnmower? The blade spinning. Some states, courts have said that's an inherently dangerous piece of equipment. So it depends on the equipment. If we say a chair that you sit in, is that inherently dangerous? The response would be no. So what happens if you sit in a chair and it collapses? That falls under negligence law. You have to show there was a duty to maintain it or a duty to build it correctly and that there's a breach of duty. And again, the proximate cause and damages. The idea with strict liability, in this instance, product liability, the individual, if they can show it's inherently dangerous, then the party that owns that particular item is liable. And the party that's injured then tries to collect those monies. Okay, now, two different cases. We have the Ryland versus Fletcher case. I have that in these materials. And with that in mind, significantly different decision than what your textbook talks about in regards to the Texas court case. As I put in the materials, opposite conclusion. Okay. Why? Well, the Ryan case is an English case, the Texas court case, United States. But it really doesn't make any difference. Why? Because the courts decide whether something falls under strict liability or whether it falls under negligence. So it's up to the court to decide these factual issues. Now, the structure of law, or the structure of the court. All that really means, in my mind at least, is that we have a trial level, whether it's at state or the federal level. Then we have an appeals court. We call that an appellate level, both at the state level and the federal level. And then what else do we have? We have a Supreme Court, state Supreme Court, and federal Supreme Court. Now, your author talks about it being very confusing, a tangle of laws, precedents, okay? With that in mind, yes, we have overlapping laws. We probably could take the Krannert building and probably with all the laws that a business person or an individual has to comply with. I like business person, let's say, that operates globally in all 50 states. That building isn't large enough to hold those laws if we use the actual books that they're printed on. Now, easy to hold it if they're all digital, and that's what we have in our libraries here, so it's easier to find particular information. Okay, now, that's the end of the introduction, and so with that in mind, I have just one last thing that I wanted to mention, and that dealt with executive orders. What are executive orders? Well, they're not really laws. Why aren't they laws? Because the legislature hasn't passed them, or they haven't been passed by cities or counties or small municipal groups that would be ordinances. It's just something that the king, well, not the king, but the president, which is similar to, under English law, what the king used to be able to do. Today, just a figurehead. But the idea of executive orders, and that's where in your materials you'll see this piece of information. Whoop, let me get to that. Is where the court, where the president can issue what appears to be like laws. Why does it appear to be like laws? Because parties need to follow them. But what parties follow them? Only the government. Now, others can, but in this instance, I use an example of, let's say, John F. Kennedy, where he required that contracts with the federal government, that companies that contracted with the federal government couldn't discriminate in regards to race, color, religion, and national origin. Okay? So with that in mind, he controls purchases for the federal government. Now, he doesn't personally operate as a purchasing agent or purchasing manager. That responsibility is delegated. But he can tell them what they can or can't do. Why? Because that's in his area of control. So this executive order dealt with not discriminating in regard to people of race, color, religion, or national origin, provides something that the government has set up in regards to their purchases. Now, once he died, Lyndon B. Johnson, his vice president, becomes president, pushes through this executive order as a new statute. Today we call it the Act, Civil Rights Act, also called Title VII, and it includes those particular terms that I just mentioned, race, color, religion, national origin, but sex was also added to it in regard to the gender of the individual. So, a little bit different, more broad, okay, in regard to those individuals that employ 15 or more employees, can't discriminate. So it doesn't just relate to the federal government, relates to any employer that employs 15 or more parties. So we can have laws that started out as executive orders and then become laws that the rest of society has to comply with, but most of them don't. So the end of chapter 1 and the materials for this particular lecture.